Good afternoon and welcome to this webinar on employment law. My name is Malcolm Fleming, Chief Executive of the NZIOB. The first wave of the NZIOB's COVID-19 themed webinars focused on key issues that the NZIOB membership and broader construction industry required urgent information on. Those initial webinar topics covered contracts, wellbeing and guidance on how to operate sites under Level 3. A topic that has been an important one from the outset of COVID-19 has been employment law. It is a subject that those who have attended our webinars over the past 8 weeks have regularly suggested should be included in our webinar program. For the NZIOB, whose members includes employers and employees, it was important for us that any presentation on employment law provides accurate and valuable guidance to both employer and employees. We therefore approached today's presenter, Olivia Lund, who has regularly represented both companies and employees. Olivia is a partner at Duncan Cotterill and leads the Wellington Employment and Health and Safety team for that practice. Olivia was recently on Radio New Zealand's Morning Report, providing commentary on health and safety aspects that companies need to consider when reopening under COVID-19 Level 2. Today's webinar is being recorded, with the video and the PowerPoint slides being available to NZIOB members on the members' portals, and they'll be available from either this evening or from tomorrow morning. Before I hand over to Olivia, I would like to make you aware of some upcoming COVID-19 themed webinars that are currently under development. First of those is financial management, which we're targeting to deliver in 2 weeks' time. We also have a webinar specifically on construction site programming, and that's programming under Level 2 distancing restrictions. And we're going to be circling back to the wellbeing topic with Site Safe and mates in construction once their team start to get a feel for what issues are being raised on site a month into operating at Level 2. So enjoy today's webinar and please pose any questions you have on the question function on the platform webinar. I will rejoin the webinar at the conclusion of Olivia's presentation and facilitate the Q&A question. I'll also ensure that we finish promptly at 1 p.m. so that attendees can catch today's COVID-19 briefing. So over to you, Olivia.
Thanks, Malcolm. Hello, everybody. It's a pleasure for me to be able to present to you today. As Malcolm said in his introduction, I have been running a number of these and I've lost count now, but the employment side of COVID-19 has been a very busy one for our firm, particularly at the start around the lockdown and what the obligations were relating to employers who couldn't work during the lockdown and how they managed that with their employees around pay, standing them down, variations to their employment, and also restructuring as well. And then what complicated that response but helpfully assisted a lot of organisations to maintain and retain their employees was the wage subsidy that was put forward by the government. So that threw up a lot of questions both for employers and employees as to how that wage subsidy sat with the general employment law. So the government kind of was quick to get that out and available for employers, but there was a lot of scrambling even amongst the legal profession as to how those provisions were to be interpreted, what the obligations were, and what the legal requirements are. So what I'm going to talk through today is just to outline what the key employer obligations are, and then to discuss how they relate to the wage subsidy scheme and what the requirements are, because that then impacts on what an employer is able to do in terms of restructuring or redundancy, and also changes that they might need to make to an employee's pay or their other terms and conditions. And then looking forward, just some observations as to what we think will be likely claims arising out of actions that employers have taken to date and going forward out of COVID-19 as we see, a significant downturn in businesses and organisations starting to make changes to their workforce to reduce costs. So the key employment obligations that relate to an employment relationship are set out in these pieces of legislation. So the Employment Relations Act, the Health and Safety at Work Act, and the Holidays Act. But most importantly as well, it's also the individual employment agreement and policies that apply to those specific employees. So sometimes people actually forget that they might have more generous obligations and terms and conditions of employment that apply to their workforce. So it's important not to forget actually to go back to your employment agreement and policies and look at what they say when thinking about making a proposal, or what your employer might be doing in terms of changes to your own terms and conditions around consultation and how that process should be conducted. So under the Employment Relations Act, the main obligation is this obligation of good faith, and that applies for both the employer and the employee, and it underpins the entire employment relationship. What the duty requires is that both the employer and employee must be active and constructive in maintaining that relationship. So it requires them to be communicative with each other and responsive. So when you've got an employer that is coming to you with a proposal around making changes to your work or the terms and conditions of your employment, they need to be making sure that they give you sufficient information for you to assess what's being proposed, and so you can go away and take advice on that and give feedback on what's being proposed. And providing relevant information is actually a high threshold. So quite often when employers are making decisions in the current climate that we have with COVID-19, they're making fast decisions, and in some cases not on a lot of financial information to back up the decisions that are being made. So there needs to be, like in any case, sufficient information to support a proposal or change that is being made. That needs to be disclosed to that employee. They need to be given sufficient time to consider that and look at that. And the employer needs to consider what the employee comes back with an open mind. So this good faith obligation relates to every aspect essentially of the employment relationship. Going forward, and what I've added in here is what we call the test for justification. So early on, there were a lot of businesses who were making decisions on the basis that this was a global pandemic. It was an unprecedented time. Essentially, employment law obligations went out the window, and we were seeing a number of large corporate organisations making unilateral changes, reductions of pay without any consultation. And the reasons why we saw that to start is that organisations were saying, well, actually, my actions are reasonable and fair in the circumstances because of this unprecedented COVID-19 situation that we have. There's mixed views within the profession as to whether that would actually stand up, and I think that a lot of people will be caught short actually by making really robust decisions in what was a difficult time, not only for employees but also the employers. So when we look at claims that are going to come, and I'll talk about what they might be later on, what the authority in the employment court is going to do is apply this test and say, well, essentially, how did that employer act, and was that what a fair and reasonable employer could have done in the circumstances at the time? Now, the circumstances at the time is the key thing here as to we were unsure as to how the authority in employment court is going to say what was reasonable and what was not. There's a clear acceptance amongst legal professionals, practitioners, employment practitioners, that these are unprecedented. So what would have been fair and reasonable prior to COVID-19 is probably going to be relaxed in the current circumstances. So the wage subsidy scheme came in pretty quickly actually in terms of the lockdown, and I'm hoping that a lot of people online today will be familiar with what the scheme provides, and it's just been extended by the government but with different terms. So essentially, a business or organisation in New Zealand is entitled to apply for the wage subsidy scheme if they can show that there is an actual or predicted reduction in revenue for at least 30% for 1 month prior to their application. So essentially, it was open from February till June, and if you could show that there was a 1 month for 1 month period a 30% downturn in revenue and sales. So it's not related to profit, it's purely revenue sales coming in the door compared to the same time last year, you would qualify for that. A lot of the applications and where organisations are being criticised is that they have based them on predicted reductions, forecasted reductions in revenue. So businesses that weren't able to trade had to close their doors and shut down or meet that threshold easily. Where we're going to see potentially audits and reviews coming in of applications is the basis upon which forecasted or predicted downturn in revenue and sales was made. So was that based on, you know, a genuine belief, reasonable financial accounting? Was the external accounting advice sought as to assess their organisation's decision and belief that it was valid in terms of having that 30% decline? So what we're seeing is a lot of organisations obviously applied for that, and the threshold to meet it was actually quite low because it wasn't actual, it was just forecasted. That subsidy was in place for 12 weeks and we're going to see that run out shortly, and that's why the government has announced that there'll be a new extension to that subsidy, but organisations are going to have to reapply for that and the threshold has gone up. So they're going to have to show a 50% actual or predicted downturn in revenue for 30 days prior to the application. Now, there are a whole bunch of declarations and obligations that go with applying for the subsidy. So the employer needs to show that they've taken active steps to mitigate the impact on the business, which I'll talk about shortly. And they also need the employee's consent to make the application. Early on, there was a whole bunch of employers that were basically just making the applications and not engaging with their employees to let them know that they had applied, but also they needed to have consent of those employees because their private information was being shared with MSD to make that application. So unless there was a term in that employee's employment agreement that provided the ability to disclose that employee's private information, those employers really should have got those employees' consent. So the obligations in relation to the payment of the subsidy. So employers have to use their best endeavours to maintain 80% of normal pay. And best endeavours, I'll talk about the definition of that, but it is actually high, but it doesn't mean that you need to go out of business. Depending on when the application was made, so the government changed the declaration of obligations on the 27th of March. And this is important for organisations who are thinking about restructuring and redundancies. So any applications for the wage subsidy that were applied for prior to 27 March at 4 p.m, they're not required to retain their employees. They just need to use their best endeavours to retain those employees for the 12 weeks they received the subsidy. If the application was made after the 27th of March, then they must retain those employees for the 12 weeks. But that doesn't mean actually a restructure or redundancy process can't commence during that 12 weeks that that employee is receiving the wage subsidy. So in terms of the requirements around fulfilling the obligations that an employer has when applying for the wage subsidy, they must take active steps to mitigate the impact on the business. So this involves engaging with the bank, drawing on cash reserves, making an insurance claim if there is one available, and most insurance policies would probably actually, in terms of business interruption cover, would exclude cover because of the pandemic, but there are some policies out there that are responding, particularly organisations which had to close down and couldn't operate. They also need to maintain, reserves, 3 to 6 months of reserves. So it doesn't need to be to the point that the organisation is on the brink of insolvency and essentially that you're exhausting all cash flow. What we saw from a lot of organisations is that there was a mutual approach. So they would come to us from the legal side in terms of how do we manage this from an employment perspective, but they'd also be engaging with their accountants around forecasting budgets and making kind of assumptions as to what are our expenses going forward, how can we make some savings before we have to look at reducing our staff's pay and applying for the wage subsidy. So best endeavours, so this best endeavours is in relation to the requirement to continue to pay employees 80% of their normal pay. And this obligation applies both pre and post the 27th of March date, and it will also apply for organisations and businesses applying for the extended wage subsidy on 10 June. So best endeavours, it's an onerous standard. It requires actually that an organisation might act against their own commercial interests, incur some expenses. So we've seen a number of organisations, particularly where you've got shareholders there, reducing their earnings and profits that they're taking out of the company, not making any distributions. All of those things would need to be taken to meet that threshold of best endeavours to pay staff 80%. The test obviously is an objective one, so a party is required to apply itself conscientiously to the task, but also with mind that they have to protect and be prudent about its own interests. So it needs to be reasonable in the circumstances that it's not going to put the business out. What we saw happening in practice is there was a mixed approach. So there was some uncertainty around how long the lockdown was going to go on for. We had a number of clients coming to us to say, okay, we can pay 100% of pay with the wage subsidy, but we can only do that for 4 months. And then we're going to have to drop down to 80% for the next 2 weeks, depending on how long that lasts. So it was kind of a staggered approach. And then there was this constant reassessment as to, can we afford to maintain our staff on the current levels? What does it look like going forward? So a lot of the clients that I dealt with, we did it on a kind of a set time frame, and then it was 100% or 80%, and then it would go down from there. And that was pretty much in relation to staff who could still do some level of work from home. For organisations that couldn't work at all, and the construction, building was one of those, some organisations just could not afford to continue to pay their staff at 80%. So what we saw is that essentially the employees were stood down, and then there was an agreement that they would pay that wage subsidy as a minimum over to those employees, which was fine as long as the correct process was followed. So on the slide here, I've got some misconceptions around the pay, and I've already touched on, a lot of organisations just applied for the wage subsidy and passed that on and didn't make any attempt to look at paying their staff 80% of their pay. So that was wrong. There was also confusion around whether employers could ask their employees to use annual leave or direct them to do so. So the position on that is that an employer should consult with the employee about the taking of annual leave. And in this situation, particularly the lockdown, employees weren't particularly minded to take the annual leave because it was of no real benefit to them. So there was some resistance by employees being asked to take their annual leave. If the employer has consulted and tried to reach agreement with those employees about taking the leave and no agreement has been reached, there is the ability under the Holidays Act for an employer to essentially direct that employee to take their annual leave, but they need to give 14 days notice for that. So we saw some employers doing that, particularly where they had large balances of accrued leave sitting on their books. Other employers dealt with it in a way of if they couldn't pay the 100% of normal pay, that they would go down to 80% of pay, and they would allow employees to take the annual leave essentially to top it up. And that was fine as well, as long as there was agreement amongst the employers who were being consulted about that. There was a lot of confusion around what was the obligation to pay employees if they couldn't work at all, and this is still a debatable position. And the difficulty around it comes from whether the employee is ready, willing and able to work. So if an employee is ready, willing and able to work, they should be paid. And in this situation, we had obviously employers weren't able to provide work for their employees. So who was at fault? Was it the employee or was it the employer? Where we kind of fell out that unless there was a business interruption clause in the employment agreement, which in a lot of employment agreements there which would provide in the situation of a pandemic, the employer is not required to pay the employee because they're deemed to be not able to work in those circumstances. So that was clear. There was no obligation to pay in that situation. But where there wasn't such a provision in an employment agreement, or it was unclear or didn't expressly refer to a pandemic situation, we thought that actually it was reasonable for an employer to form the view that the employee wasn't ready, willing and able to work because of the government lockdown, and so therefore they weren't due to be paid their full normal pay. And in those situations, we've seen obviously the employers apply for the wage subsidy, and that was the intention by the government in bringing that about. And so the minimum wage subsidy would be paid to those employees. So this leads us to redundancies and restructuring. So obviously this will depend on if the employer who has applied for the wage subsidy, what the obligations are. So as I said earlier, the government made a significant change in relation to the wage subsidy on the 27th of March. So employers who applied for it prior to the 27th of March, they could actually still go through a restructure process and make those employees redundant. Those that applied after, they've got the obligation to retain the staff. But as I said earlier, they can start the process of restructuring and give notice of that termination. But it must be during the 12-week period. So essentially what we were saying to employers is that if you applied after that 27th of March, and 12 weeks is a long time, and early on employers were saying to us, we're not going to be able to retain all of our staff. Even as we work through the different levels of lockdown, it's not as what we thought it would be, or it's a lot worse than what we thought it would be. So we now need to look at resizing our workforce. Can we do that, and can we start the process now? So yes, you can start the process, and the process now out of lockdown, I think, probably goes back to being more aligned in terms of a longer process of and it depends on the organisation, but 1 to 2 weeks to come up with a proposal for a restructure, and then consultation with staff, and then depending on how many positions are affected and how many employees are affected, you would then go through a redeployment and selection criteria, and that's the difficult stage, which I'll touch on shortly. But essentially you could start that process because it takes some time, and then you could give notice of termination within the 12-week period, as long as the termination, the employment, ends after that 12-week period. So moving on to the standard restructuring process. So just to share some observations of what I saw at the start, there were a number of particularly hospitality organisations who were and tourist operators who were significantly impacted and could see that they were going to be for the foreseeable future. So they quite early on went through a restructuring process throughout the level 4 lockdown and level 3 lockdown, when they wouldn't have the usual ways of gauging with their employees. So that was quite a quick process that they went through to try and preserve their position in terms of restructuring and making employees redundant. And there was a flurry of activity to start with. And then people applied for the wage subsidy. And then I think there was a bit of a holding pattern. People were waiting to see, well, how long are we going to be in lockdown for? What is this going to look at? How significant is this recession going to be before they made decisions? And now we're starting to see some employers say, well, actually, this has really hurt us and it's not looking good in the future. So we need to start a restructure process. So we're now seeing more employers start this. So just like any standard restructuring process prior to COVID-19, the same obligations apply. So there needs to be a proposal. And what we're talking about there is a proper business case for the restructure and the redundancy. And it needs to be a genuine. So if there has been a significant downturn in sales or revenue, loss of customers, suppliers, a shift in the market, all of that is likely to be a genuine reason for a restructure or redundancy. It should be documented in a business case, and then that is going to need to be shared with employees, so they can look at, well, what is the base information that my employer is essentially basing decisions on that are going to impact on me? Are these assumptions correct? Are they fair? Are they reasonable in the circumstances? So the proposal for the restructure and redundancy and the business case behind that supports it needs to be provided to employees, so they have the opportunity to look at it and they need to be consulted on that. Before the restructure process, and I go on, employers should, I'll remind again, look at the terms of the employment agreement and what the policies you have in place, because they may require a more onerous obligation on the employer when going through this restructuring process. So employers need to be open and communicative and constructive with employees, and provide all information essentially that they are making their decisions on with employees. And this is where we see a lot of action in terms of lawyers becoming involved and challenging decisions. So early on it was hard and fast actually, and some gut decisions were made and probably were genuine and right, but they weren't actually backed up with the same level of business case and financial information that should be there to support a proposal to restructure and then make employees redundant. So early on we would see employees raising questions around, well, where's the information behind this? Disclose this. Have you made an insurance claim? What's going to happen with the wage subsidy? So my advice actually is to preempt all of that. If you are an organisation that is thinking about or contemplating a restructure process, you need to have all of this done up front. So then you're not scrambling and responding to your employees as they start to question and ask for information requests, because that's what slows it up, but also calls into question the genuineness about the proposal that is being made. So once you put that to your employees, you need to give them a reasonable opportunity to consider that and to take advice and to provide feedback to you. So that might be provided in a number of ways. During lockdown, people were asking, well, how do we do that? Generally, it would be in person when you would provide that opportunity to give feedback, and obviously people couldn't do that. So using technology is fine. It did provide some difficulties where you would have multiple parties. Some people wanted lawyers there or a support person, and people can accommodate that. We had sometimes people on Zoom running meetings. They would have their lawyer or support person who couldn't access Zoom or some other platform on the phone. So as long as you're making genuine and reasonable attempts to allow your employees to have access to their legal advice or support person and give that feedback, then the employer would be meeting their obligation. Once all the feedback has been provided, then it's reaching a decision on whether you're going through the proposal or not. Before you do that, you need to consider alternatives to redundancy. So in COVID-19, we're seeing a whole bunch of different scenarios and alternatives that are being explored. Is it that it's a reduction in pay before you restructure and make people redundant? And we saw a lot more of that being proposed by organisations than we otherwise would have, and I think that thought has come about from obviously the wage subsidy and that obligation that there is that support there, but that obligation to pay your employees 80%. So it was kind of this sharing the pain mentality. But that then caused difficulties where you would have a reduction in pay for some, but you would have very busy workers who were essentially doing 100% of hours, if not more, but only on 80% of pay, and then other pockets of the business were only 30-40% of capacity working, but still getting 80% of pay. So it caused a whole bunch of difficulties there. And what was the right approach? Is it a change to the terms and conditions, a reduction of pay, or should we be restructuring? Can we redeploy our staff? So can they do other jobs? Is it part-time roles? Is it fixed-term roles? All of those things need to be considered before terminating an employee's position. once you've got to the point of having kind of a set proposal and a restructure confirmed in terms of decision making, then you need to decide, well, what's the selection criteria and how are you going to appoint employees, those affected employees, into those remaining roles. And there are a whole number of ways that this can be approached. Some organisations will have a policy. It might be, first on, last off, or it might be a whole bunch of collectives apply to different sets of employees, which means that they need to be treated differently. If it's going to be merit-based, then you need to be really careful about what the criteria is and making sure that you share with those employees, if it is merit-based, how they have been rated essentially against that criteria, and they get the opportunity to provide feedback on that. And then after that point, you'll be deciding which employees are going to be retained or made redundant, and then giving the required notice of termination under the employment agreement. So there is no statutory redundancy compensation under the Act. There was, and it depends on the organisation, there are some organisations that do have redundancy compensation paid over and above. They tend to be government departments and organisations or people under collective agreements where that has been negotiated and agreed to on their behalf, or long-standing employees who are under agreements where there was that redundancy compensation. The majority, I would say, of individual employment agreements that I see now, ones that are firm drafts, they don't provide any additional redundancy compensation. It'll just be the notice period essentially that is paid out. So the difficulties that we are seeing now with organisations, and some of them are in such dire financial circumstances, is that they actually, regardless of what an employee comes back with in terms of giving feedback or looking at alternatives, they can't actually engage in this process properly. So they're thinking, well, what's the point? I'm going into liquidation. I can't pay out the notice, contractual entitlements. So they just make a decision and then notify their employee of that, which will expose them and give rise to obviously a valid personal grievance claim. So it's difficult in terms of turning my mind, and Malcolm was really gave me the message I need to try and make sure I give advice to employees in this situation, and it is difficult. The tips that I would say to an employee who's being faced with this proposal, it definitely depends on the organisation. If it's a large organisation that is going to be long-standing and come out the other side of COVID-19 with potentially a smaller workforce, then it's engaging in it in good faith and trying to be constructive, not critical, and thinking of ways that you might be able to challenge potentially what the employer's decision is, but in a way that's not going to then be a black mark essentially against your name as someone who's being, troublesome, or a black mark in terms of selecting who might be then appointed to a position that they might think, well, you've been difficult during this process, and that might count against you. So one, it's engaging in the process, being open-minded, and also thinking about the way that you present your feedback. I think that the biggest area that employees can create value in a restructuring process is actually a lot of the time organisations, particularly large ones, when they come up with a restructuring proposal, there's a misinformation around actually how things are done in practice. So a whole bunch of assumptions are made as to, well, what sort of resourcing and capacity do we need within this team? And they make that on the basis of position descriptions and employment agreements and how they think a team actually operates. But that doesn't reflect what operates in practice. So employees going through a restructure process when these decisions are being made can add value and support their position by making sure the decision makers have got an accurate picture actually as to what are the needs of the organisation, who is actually doing what back to the employer when they're making decisions, but also being realistic and perhaps a little bit proactive in offering up alternatives. So if it's clear to you that you are not going to survive the process, would you be open to a part-time role, or would you be open to a sabbatical or redeployment into a totally different role that you might not have the skill set for, that you might be prepared to do additional training for. So being open to those other alternatives that you might not otherwise be would probably put you in good stead. So I've got a slide up here in terms of COVID-19 specific restructuring, and I've already talked about these as to what's fair in terms of the process to follow, so I won't touch on them any further. So entitlements to payment, variation of rem and use of annual leave, I've already touched on these, but I'll just cover them because I think that they are important, particularly when I get on to discussing, well, what sort of claims do we think will come in the future. So the first one is was that employee, particularly during the lockdown, entitled to be paid, and this whole question around whether they were ready, willing and able to work. So obviously if the employee was working, then they were entitled to be paid at their normal pay unless there was any variation to their contract. So if you were working from home during the lockdown period, your employer should have been paying you 100% of your pay. They shouldn't have dropped it down to 80% of pay just because they've applied for the wage subsidy or they're doing it tough. If they have, however, consulted with you around reduction of pay because finances and cash flow are tight, well then that is okay, but it needs to be by agreement. If you were an employee and you weren't working during the lockdown period, we say you're not ready and willing and able to work, then you're not entitled to be paid. So this slide sets out the obligations and proposing variations. So variations cover a whole number of things. It's not just pay. So that was the key thing and the most common change in terms and conditions that we saw. But we also saw employers taking away benefits that weren't being used. So travel allowances or accommodation allowances that would routinely be applied and paid, or vehicle expenses and allowances, or well-being such as gym memberships or Koru memberships, all of those sorts of things. Some employers just cut them, but actually that probably wasn't fair and would be open to challenge by an employee. So whenever there's any change to the standard terms and conditions of an employee's employment, they should be following a proper consultation and bargaining process and making sure that their obligations are good faith and met. So if there has been any changes to terms and conditions of employment, an employee may be able to challenge that if there hasn't been clear agreement around that. Again, the process is similar to the restructure process. Whenever there are changes, you need to communicate what the proposal is, put it to your employees, give them the opportunity to respond to that or not. Make sure they have enough time to get legal advice, setting clear timeframes around responses, and ensuring that you've got a positive agreement there. So best practice, we would say you should have agreement in writing to any variations to terms and conditions of employment. So what we would do is we would draft up essentially for clients letters setting out, this is the proposal around variations to hours and terms, provide your feedback by this date, and then the decision would be, after that, would be confirmed, and then at the bottom there would be a section essentially where the employee could sign their name saying that they understand, they've had the opportunity to take legal advice and they agree to that. Obviously that wasn't possible for all employees, and depending on the makeup of your employees, some weren't requiring that and would essentially just say, well look, by return email just say, yeah, you're okay and you're happy with that. Anything in writing is better than nothing at all, because it makes sure that that there is clear agreement. If it's not in writing, it's easier to challenge. Employees will come back saying, oh, I didn't understand that, or I didn't actually agree to that, or I agree to this part of the proposal and not that part of the proposal. So that's where there is a risk around that. And particularly if you are an employee and this has been put forward to you, what I would suggest to you is making sure that there are clear timeframes and a clear understanding of what's being proposed. So is it, if there is a reduction in pay, that your pay is being reduced or your hours are being reduced to 80% or 60%? Is that for 1 month? Is that indefinite? Is it 2 months? You know, how long is that process for? What are the review obligations on the employer? You know, are you saying, okay, I agree that there's not enough work, so I'll reduce my hours to 80% and get 80% of pay, but that's going to be reviewed at the end of the month period. So there's all those sorts of things that an employee, if the employer hasn't been clear in their proposal, that you could go back on, and potentially if it has been proposed that it's indefinite, you might push back on that and say, actually, we don't know what the future looks like, let's just do it month by month, or do it you know, bi-monthly, or what have you, whatever you think is reasonable in the circumstances. So I've already touched on the use of annual leave there. Even in the closed down period, you know, people were being instructed to take annual leave, but we're now seeing that come up again, even when we're now back at work under Alert Level 2. So the first obligation obviously is to consult with your staff to take annual leave. If you can't reach agreement, then the employer does have that ability to give notice, 14 days notice. So likely claims, what we're going to see coming out of actions that have been taken in relation to COVID-19. So obviously there's that 90-day statutory time frame for bringing a personal grievance claim, and there will be two types of claim. One will be unjustified dismissal claims. So this will be in relation to redundancies or dismissals where they have been for poor performance or disciplinary process. That's the general one. Or unjustified disadvantage claims. So these are going to be, as I've talked about, where employers have either taken away or reduced benefits, if there has been unilateral variations to an employee's pay without their consent, or in relation to wage subsidy obligations. So has the employer met their obligations to pay 80% of pay, and have they passed on the wage subsidy as they are required to do? Any unlawful direction to use annual leave, so that would also give rise to a disadvantage claim there. So if the employer hasn't tried to reach an agreement there and has directed staff to take the annual leave, then that might give rise to a valid disadvantage claim. But also breach of good faith, that will be another one that I think, arising out of the pandemic, where we've seen really robust decision making. And in my view, employers essentially completely disregarding their employment obligations and having no aspect of trust and confidence and being responsible or communicative with their employees. We might see higher penalties being imposed against those employers who have essentially breached their good faith obligation. So I've got in here, it's a slide, exclusions from cover. So there is, for business owners who are online today, there is insurance cover policies available, and a lot of the time employers aren't aware that they actually have a policy that might respond to an employment dispute. The problem that we are already starting to see is that generally insurance insurance policies provide cover for a personal grievance claim where there is a claim for compensation for hurt and humiliation or some wrongful act that the employer has done. The insurance policy won't provide cover for what I've listed up there, what are contractual entitlements that employee was owed. So that will be things such as wage arrears claims. So if you had an employer who has reduced pay, and then that employee comes back and says, well, that was unfair, I didn't agree to that, that will be a wage arrears claim. And so the insurance policy won't provide cover for that because it was a contractual entitlement that employee was entitled to. So there won't be cover for that. There's no cover for redundancy compensation and the other things there around, requirements to take annual leave. If there is a personal grievance claim for unjustified dismissal, the primary remedy now, which was changed a couple of years ago, is this reinstatement. So is it practicable and reasonable for, let's say, an employee who has been made redundant and that has been challenged, either the process of that restructure has been unfair or unreasonable, or the substantive decision wasn't genuine, the two aspects can be challenged. Well, then an employee's main remedy would be, well, right, I want to be reinstated back to that position, and so they might apply for interim reinstatement. So there are difficulties that arise with that, obviously, if there has been a change to the workforce and what is practical and reasonable going forward. We haven't seen any cases, and we're not sure what the authorities' response is going to be in the current economic climate around reinstatement, particularly if the work is not there. So are they going to order interim reinstatement and require employers to essentially hold the position open while the dispute then goes through the legal process, which can take months, if not, up to a year to get an outcome. So we're just not sure what the process would be. But the reinstatement, if that does occur, creates some difficulties around insurance cover, because there won't be any insurance cover for essentially unpaid wages for that whole reinstatement. So if you have an employee who is then reinstated to their position, the employer is then obligated to essentially pay those wages back what they would have otherwise earned. And so there won't be any insurance cover available for that. So that brings me to the end of my slides. Just on the insurance side of things, most insurance policies that we deal with have an obligation on the employer to take proper advice before taking any steps and to follow that advice, and that might be from a lawyer or an approved legal provider, depending on who your insurer is. So my advice is, before you're taking any steps that might impact on your staff or give rise to a potential personal grievance claim, whether unjustified dismissal or a disadvantage claim, seek advice from either a lawyer or someone who's approved by your insurer. And you can ask your broker, if you're unsure about that, to make sure that you meet that first requirement, because quite often we'll see claims that are knocked out because employers haven't complied with their obligation there.
Great, thanks very much, Olivia. Just before we get to the questions, and we do have a couple of questions there, I just want to marry up two themes that you've been talking about. One was the comment that during the early days of COVID-19, and just recognising that we've gone through a bit of a life cycle, an unfinished life cycle, but going through a bit of a cycle with COVID-19, the comment that early on some employers were disregarding their employment obligations, so just taking that. Also the overriding test in terms of employment being that threshold for circumstances at the time. And you followed up making a comment that the profession is generally accepted amongst the profession that COVID-19 represents an unprecedented event. So I'm just sort of trying to marry up some of those early responses from employers, and some of them were effectively instructions to take leave, to reduce hours, reduce pay, etc. And with that, that benchmark, if you like, about circumstances at the time. So is that benchmark is probably undergoing some movements, vertical movements through the early days of COVID-19 through to where we are now? Do you think it was?
Yes. Yeah, I think at the start, obviously, there was quite a bit of panic, would be my observation, but also confusion around, well, what actually are the obligations, particularly in relation to pay, where you essentially have got a workforce that can't turn up and perform their work. So actually, they shouldn't be paid for that. I think it will be a case-by-case analysis and dependent on the organisation. we had some clients say to us, well, look, we're taking this action because it's in the best interest of all of our employees. So they would make a unilateral decision where they didn't have consent of all employees to reduce pay purely because it was in the greater good for everyone, not just against a couple of employees or a few employees who, didn't agree with what was being proposed. So I think there was a shift actually in terms of the advice that I was seeing, particularly even in some media, where there were some employment lawyers giving advice that actually you could take pretty robust decisions. Turned a little bit when the government changed the wage subsidy and they brought in those obligations around retaining staff, and also that general employment law still applied. That was actually something that was in the declaration, that you need to meet your employment law obligations. And so I think people pulled back a little bit and thought actually this might be interpreted as a higher threshold than we initially thought, because no one really, and we don't have any case law or precedent that's going to help us practitioners to say, well, what would the authority do here? What would the employment court, what would they say was reasonable for an employer in those circumstances? Because we just haven't had this before.
Okay, there's a question here. If an employer offers to work from home further, does she have to cover some does the employer have to cover some employee expenses involved with that, electricity, internet, etc.? We're going to get more of this going forward, because there'll be a number of employees have a preference to work some of their time at home.
Yep, it's a good question, and even just one that our firm's grappling with as well. So you would want to have a clear work from home policy and clear terms around, well, what's covered and what's at the expense of the employer and what's at the expense of the employee. Lots of organisations wouldn't have contemplated that they were working from home, so it might be going back to the employment agreement and looking at, well, is there a clause in there that looks at, well, have there been any expenses incurred by that employee carrying out their work from home that the employer should really pick up? So that might be things such as the employers use their personal cell phone or data, to engage in work calls, internet usage. We're seeing some people, claim for that. And so I think it probably is a fair and reasonable claim that an employee would have if they have incurred additional costs and they can show that they are additional over and above what they would otherwise incur for work purposes, then that they would have a claim for that against their employer. Obviously, though, an employer doesn't need to agree to their employees working from home on a long-term basis. So I think there's going to be a bit of a reset where both employers and employees are going to think, well, is this going to be a permanent feature going forward, which for a lot of organisations it is. So how are we going to deal with this? Are you, the employee, responsible for paying for your home office setup? How can the employer go about, if they're not going to pay for that support, their employer to set up their home office? Can there be some sort of cost saving if there's bulk purchases made, that sort of thing? And then what clearly are the obligations around provision of internet, cell phone, heating, costs? So if an organisation is now going to change and they are going to allow their staff to work from home, then it's being clear as to, well, who's obligated and who's responsible for paying the costs of that and how that'll be managed going forward.
And that sort of question from working at home also feeds into that discussion we had before we went on live about health and safety responsibility that an employer might have for an employee who works at home. So that came up for us at a quite high level meeting I was involved in yesterday. So I'm sure that's on the minds of a number of employers on this call. So perhaps you just want to some feedback on that.
So the short answer to that question is yes. So when you have employees working from home, there is that health and safety obligation to make sure that your employees are not harmed at work, but it's only to the limit that the employer has the ability to control what risks or hazards are in the workplace as a result of the work. So the most obvious risks and hazards with working from home are the ergonomics of not having a proper workstation set up. it'll be slips, trips and falls associated with cords around, your laptops and screens. So making sure employees are aware of that. And there's a mixed view. So it's not to the point that you're going to have the employer come to each individual's house and assess and make it safe, but it's identifying what risks and hazards in the employee's home will be present and how they need to manage and control that, just like in the workplace, giving them sufficient information and instruction, but also around, taking regular breaks, eating well, sleeping well, creating some kind of boundaries, but also the mental stress and anxiety that you might see more from people being isolated from their peers or solo working from home. So thinking about those sorts of things. So there's great resources online. The Government Health and Safety Lead has a toolkit for organisations in terms of meeting their health and safety obligations for employees working from home.
That's great. We've got about 3-4 minutes left. There's a couple of questions here, well, 2 questions asking the same thing. Effectively, employers taking the 12-week subsidy, but had everybody back at work, presumably fully utilised for weeks 7 through to 12. They're asking, do they need to rebate the subsidy? That's a simple one. Do you want to give an answer to that?
Do they need to repay it? No. So if you meet the threshold in terms of you've had a 30% downturn, well, then you don't need to repay it.
Okay. Another one here was paying their staff 80%, which was structured both through wage subsidy and their annual leave, presumably asking the employee to take annual leave. This was all done with consent, but is this acceptable? Presumably the answer to that is as long as the minimum paid was equal to the wage subsidy, presumably, but what's your view?
Yes, that's right. Yeah, so we saw some employers offering their employees to top up essentially. So, yep, as long as they've met those obligations around best endeavours to pay 80%. If they can't, well, then they've dropped it down and that's fine.
And here's another one, again on the wage subsidy. So they claimed the wage subsidy for each of their staff. One of the team members is moving on halfway through the 12-week subsidy period to another job. So the question here is, do they have to refund that subsidy or transfer it to the new employer?
Yeah, there's mixed positions on that. So if they, I think probably the most prudent response to that would be to call MSD and seek their advice around what to do with that payment. If they have resigned and worked out their notice period, it may be that it's acceptable for that employer to retain the subsidy. But if it's, say, a restructuring, what we have heard is employers will go to MSD and they will say, we'll just pay out the remainder of the wage subsidy to the employee.
That's great. Well, we're 1 minute to 1. We've gone through the questions. That has been wonderful advice, Olivia. Thank you so much for accepting our invitation to come and present this employment law webinar. We've come to the end of this. I think we've got a thank you slide up. There's a final slide, have we? We put up there?
Yes, there is. Thank you all, and I hope you all go well.
Thanks very much. All righty. And just once again, the slides, for NZIOB members, the slides and a full video of this presentation will be on your membership portals either later on today or first thing tomorrow morning. Thanks again.